Right. Welcome everybody. Looks like we are live. Stephen Palmieri with my good friend and I suppose business associate as well, Shiva Bhaskar, attorney. So today we're going to talk about everything arbitration, pre-arbitration, from the man, the myth, the legend, Shiva, who has actually done hundreds of these and, in fact, sued these nefarious companies as well as arbitrate against them. So, you guys,
Yep.
if you're joining us live, comment below. We do have the comments streaming in here. Shiva, for those who may not know you, just give us a little bit of a background about why you're so amazing, sir.
I'll try to live up to the introduction, folks. So thanks again, Stephen, and hey, thank you to everyone who's watching this. My name is Shiva Bhaskar. I am a consumer credit attorney slash credit repair attorney. So I'm the co-founder of Tier One Credit, along with my awesome co-pilot Tony Budry, and then also the founder of Gopal Law Group, which is a law firm that handles Fair Credit Reporting Act and Fair Debt Collection Practices Act and other issues. And in our credit repair arm and just in general, arbitration is one of the tactics that we have used to remove charge offs, collections, auto repossessions, those sorts of items, even late payments from credit reports. Um, and really, it's just something that we always knew. We were always familiar with arbitration, but really using it in this way is something that we've sort of been focusing on over the past 18 to 24 months. The past 18 months, really, I would say, is when we really ramped it up. And so in that time, have some battle scars, learn some things, but we're able to put it to work and able to start advising other credit repair companies on things they might do to implement it. And yeah, arbitration is really exciting stuff. I think it's for everyone who's frustrated, hey, I can't get this removed or I can't deliver these results. It's one of the game changers that a lot of people in the industry have, I think, are aware of and have been waiting for, but how to execute it exactly is not always clear. So that's what we're trying to get into over here.
And so, Shiva, I'm posting up right now. You have an amazing course that you've put together. It is available at arbitrationtrainingcourse.com. Discounted right now, 70% off for kind of the early adopters. Most folks kind of coming from our circle. So $597 one time. And it's not just like, here's your, take their money and then here's your modules. No, they actually get a little piece of Shiva for their purchase of the course, right? So let's talk real quick about that, and then we're going to talk about arbitration. We're going to answer everybody's questions, but well, let's back up for a second. I'm sorry, I'm a little all over the place here. Somebody says they're buying it, Facebook user. Let's talk. So why is arbitration important, actually? So Hassan, awesome, you're buying it. Rock on. Arbitrationtrainingcourse.com will get you with Shiva. So why is this important, right? Well, the whole thing, in fact, the pre-litigation idea, which Matt Listro and I have been talking about for 2.5 years in our big Facebook group, setting up disputes with teeth, right, with some sort of
Mhm.
substance. And arbitration is kind of like this secret weapon because, well, you don't even have to litigate. It's like it's contract agreement, like contract law. Like in the contract, it's the terms of the agreement that says, oh, if there's some sort of a dispute or a controversy, we agree that we will arbitrate for it. So, as an average credit repair business owner, or even if you're just a consumer watching this, credit cards, repossessions, um,
Cell phone collections,
cell
cable,
phones, those are
TV,
the
all that,
biggest criminals I was trying to
internet.
think of there. Thank you. Cell phone companies, utility companies. I mean, almost all of these contracts have arbitration provisions, and so you kind of start off with a good solid. I mean, so there's a couple ways you can kind of get into the arbitration issue. Like, what is your controversy? I mean, number one is I sent the cable box back. Which, by the way, Shiva, does anybody even use cable boxes anymore? I sent the cable box
Not in my household, but hey, more
back.
power to you if you do.
That's right. I sent the cable box back, and they're saying I didn't, and they're trying to collect from me, and well, that's a real problem. But usually, from our audience here, the problem originates from seeing that financial issue on the credit report, right? So
Right.
you do a good, solid dispute or two, which I always recommend throwing Metro 2 in there to find the errors. I mean, if there's errors, great. And then if there's some sort of like a factual underlying account issue, like, well, I mean, like this isn't even really like my balance at all because I did return the cable box. But for the average credit repair, I mean, we're not dealing with necessarily like that cable box issue. We're just dealing with credit repair, right? So you can find
Correct.
errors. There's errors all the time, although the credit bureaus would not think that I was being unbiased by saying that. But there's errors all the time. Let's just be honest here, you know.
Absolutely.
And so you need to start and have some basis for the complaint. And then, you know, after that complaint has not been properly addressed, then arbitration is a powerful tool. And so, you know, we'll save the core stuff to later because we just dived into the good stuff. So is that a good frame up, Shiva, of the practical application for a credit repair owner or a consumer of how
Yeah.
to kind of segue in and frame up into arbitration as a
Agreed.
deletion tactic, really, right? A method, a
Correct.
dispute method. So
It's
let's go
it's
ahead
a
and
method to get things removed. Yep.
let's go ahead and kind of dive in from there. So let's kind of take it. So, you know, let's talk a little bit about, you know, what is arbitration, and then I mean you can sprinkle in obviously because you've got a course now to help people because we've had so many people ask. But let's just talk, man. Take it away, Shiva. It's all you, buddy.
Sure. So arbitration is basically alternate dispute resolution, okay? ADR, if you want to call it that. So it means dispute resolution means if two parties disagree about something severely enough, where do they go? Well, they would go to court normally, right? And that's the way it's been for centuries. And arbitration is basically an alternative to going to court. And what it is, as Stephen mentioned, is provided for in the contract between two parties. So between you and the cell phone company, or you and the auto lender, or you and the credit card company, you say that, hey, instead of us going to court, we're going to resolve it through this thing called arbitration, where basically a neutral third party, sort of like a judge, usually a retired lawyer or a judge or expert of some sort, is going to sit there and listen to what the case is and share their thoughts. And ultimately make a decision. Okay. And that's basically the long and short of it. Now, why is arbitration so powerful? The irony of this whole conversation is that if you really think about it, Steve, arbitration was something that was pushed by the credit card companies and the cell phone companies and the rest as a way for them to get out of stuff, right? To get out of matters and to sort of to reduce the cost of class action lawsuits and other types of litigation. That was really their goal in this. But the thing is, if I go to court and I sue somebody, the judge is not going to call me and say, hey, Shiva, here's a bill for the time that I spent and blah, blah, blah. All that is paid for through our tax dollars, what have you. So, okay, it's a way that you can resolve disputes. But if I said, hey, you're going to do arbitration, but you have to pay for it, then effectively, if a consumer is wronged, they have no way of fighting it if they have to now go thousands of dollars in the pocket for arbitration. So thanks to some of the court rulings that came down and all of that, they said, we'll allow you to require arbitration, but if we're going to make it something that is required, most of the fees have to be paid by the business. Okay, and that's basically
Let's
the way
talk
it's
about
going to
that
work.
real quick though, because
Yeah,
there's kind of a functional real life parallel. And Robert, by the way,
sure.
we're going to get to your post here in
Yeah,
a minute,
we will.
But there's kind of a functional parallel between that and the consumer protection statutes, right? Because the statutes are
Mhm.
designed where an attorney, if they win, can get attorney's fees paid uh, by the losing party, which hopefully would be the opponent. So the idea of those statutes, like the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, is to level that uneven playing field where the consumer can go to you, an attorney, and you don't say, okay, I'm going to charge you $400 an hour. You say, okay, sign here, and when I win, because the facts are good, I'm going to get paid because the statute requires it, right? So the design of the consumer protection statutes is designed where you get paid on the back end. And what you just described for arbitration is where it's kind of the same thing, but except we don't, CROs can do this because this whole arbitration thing falls outside of the
Yeah.
judicial scope. I mean, unless you're going in there like practicing law, like, you know, I represent Susie Consumer and, you know, you violate all these things and here's why and blah, blah, blah. But I mean, if you stick to the facts and you talk about, okay, well, here's what the law is or whatever, but CROs can do this because this is not a pre-law or a legal type thing, arbitration. This is literally, they get the power of attorney, they represent the debtor,
Mhm.
and they're like, I represent the debtor, we're here to talk about your contract and your actions. and cable box issue, you guys failed to fix it, so arbitration, I'm the front man, deal with me. And with what you just said, then the consumer does not have to bear a significant amount of the costs. So this is kind of like a plan B. If you can't go to the attorneys, or in lieu of going to attorneys, you use arbitration, and you're not going to have a huge bill, because you said the court cases essentially have determined that that's the way the fee structure should go. Is that right, Shiva?
That's correct. The courts had said that, okay, fees will be paid in this way. And then as a result, the contracts have adopted that. So if you go look at a credit card arbitration contract, it does say, yeah, the initial fee has to be paid by the consumer, which is standard, because if I go to court and I file an FCRA or an FDCPA case or even a small claims, I've got to pay the initial fee. That's always been the case. And arbitration is no different. But although there are a lot of ways around the fee and still moving the arbitration forward. But yeah, they pay the fees. And as far as the issue of practice of law, the one thing I'll say, every company and everyone out there, as a CRO, you should educate yourselves on what the rules are wherever you operate. That's number one. Like, nothing that Steve or I or anyone says is, legal advice in that sense. I have to give my lawyerly disclaimer there. But arbitration is a non-traditional process compared to court. Okay, if somebody was in court bringing a small claims lawsuit or a FCRA on their own and you're advising them, it's very clearly unauthorized practice of law. When it comes to arbitration and that whole process, let's remember that it's a voluntary process. The credit card company or whoever else.
The IRS leads me to believe that the tax system is a voluntary tax system. Is there some similarities there? Is it kind of voluntary?
Well, I don't know you want to run with that one. I agree with you. But no, I mean, it is a voluntary process in the sense you signed an agreement. Okay. Hypothetically, they can choose not to engage in the arbitration. They might have other consequences or other risks they'll face, but they could choose not to. They asked you to do it. You asked them to do it. So because it's more informal, it is something that folks can get involved with. And I will say this, there's a big debate over POA, no POA. One thing we did in the course and in general, everything is structured so that if you want to do it as a POA, you can do it. If you choose not to do it as a POA, you can also do it, as long as you have your client properly authorized you. There's nothing wrong with that. So you can take multiple approaches. The point is that you're using this as a tactic to get your consumer results, and because you're pointing out real issues and real discrepancies that exist.
Rock on. Let's talk to Robert over here. So Robert says, what is a creditor more likely to ignore? A nearly powerless dispute or a potential lawsuit from arbitration? So great question, Robert. And for those of you guys who don't know, Robert is with Credzu. Check him out. He has a great escrow tool for credit repair companies. Robert, there's no such thing as a free plug. Send me some Uber Eats for lunch. For giving you my airtime there, buddy. All right, Shiva, let's go here, man. So let's talk about what Robert has to ask here. What are you thinking, brother?
Well, I'd say a few things. A dispute, I can tell you, because our arbitration process involves first doing disputes and then filing arbitration. So I would never have to file arbitration if the disputes were actually getting those results. But even with our law office doing it, the portion of credit card charge-offs that actually get removed, I'll use credit cards as an example here. The portion of charge-off credit cards that actually get removed using the disputes, even coming from an attorney, is very small. Okay, I can tell you that at the dispute stage. When you file the arbitration, now it's a complete.
Hold on a second, Shiva. I'm sorry, man, and I don't mean to be that rude guy, but I've got to say, I've seen all these websites online and these courses and these beautiful things with flashing, glittering, these coaches, and they're like, pay them like $5,000 and they're going to make you a charge-off deletion guru. Do you mean to tell me that is all fake news there, buddy?
Oh yeah, it's complete BS. And I think, as one of the guys who went as because I came from the perspective of being an attorney who understood the FCRA side, but maybe not the credit repair side. This is a number of years back, and so I'd paid some of these same people for coaching, blah blah blah, and I came to realize nobody was really doing anything innovative. It was like, oh, write your dispute this way, write it that way. Okay, all of that is fine, but your dispute's not going to matter that much if these guys know how to set it up, and if these guys can just ignore it. Okay, what don't they ignore is when there's a forced threat of something happening, whether it be litigation or arbitration. And so an arbitration you can't ignore, in the sense one of two things is going to happen. If it's properly filed, either you're going to work it out with the consumer, or pay the fees and go to arbitration, or and this is a rare one for credit card companies, almost none of them do this, not pay the fees and take the risk of being sued in a class action or being sued in court otherwise. So for the most part, most of them are going to pay attention. It doesn't even have to go to arbitration in the sense of, hey, we're moving this case forward. Just more filing to arbitration, reaching out, letting them know what's what, and going from there. It's very, very powerful.
So let's talk kind of practical approach here. Okay, I mean, so
Sure.
like with typical credit repair, you just you send letters and it's a big letter campaign. Maybe you make some phone calls. But if you're doing arbitration, um, is there the possibility that you may have to travel across the country to like some sort of a meeting room, like a mediation? Like, I mean, how do or can you?
Extremely unlikely. First of all, any arbitration can be done by phone or in person. Okay.
Okay.
I would say request in person, because the arbitrator will cost more and there'll be more fees, which means the business is going to be more hassle. Plus, you get in front of them. But if let's say you're a consumer and you want to arbitrate, you can do it via phone. So there's no need to travel anywhere. And the thing to remember is, for the most part, if the case is going to go that deep, you probably want to have a real case with, not a real case, but a case that's more substantial with a lawyer involved. Because remember, you're putting the cost of your time or your client's time in. So it's got to be much more substantial. Most of these are going to resolve much earlier, because the issue at stake is smaller and what we're asking for is different. And so most of them are going to wrap up much sooner than that. That's what I would say.
I say, especially if you're focusing on the healing the credit, getting that deletion more so than
Correct.
beating them up for a big ass check, right? I mean, I'm sure
Correct.
there's probably some balancing act there where it's like, if you're trying to get $50,000 because the cable box, I mean, they're
and
probably
and, and, that, and that's where it comes from. And I say this knowing that there are going to be, maybe not in your group, but in general, I know there are going to be folks, consumers or credit repair companies, that are going to swing for the fences and think, oh, I should get paid this, blah, blah, blah. And that's one caution I want to add about arbitration. If you file an arbitration that is groundless, with meaning it's frivolous, it's without merit, or you're being completely unreasonable in the settlement or what you're taking, it can very well be taken forward. And if they find it was done to harass or done for frivolous reasons, your client can be on the hook for the entire cost of the arbitration. They can direct costs back to the client. So I say this to tell folks, be realistic in what you're asking for and what you're trying to accomplish, because it's very, very powerful. It can really take your credit repair business to the next level. But I know some folks are sitting there and thinking about, how can I just use this? Yes, there are situations where there's damages and money can be made, without a doubt. Okay, but be cautious of that, because if as like anything else, if we push too far, it can go sideways. I mean, I know a great story that one of our colleagues in the group and fellow attorney who I work with, Mike Cardoza, shared, of someone who, they had a bankruptcy that was legitimately theirs. They filed it. There was nothing major inaccurate. They wanted it removed, so they went and sued Experian in small claims court. Okay, and Experian basically closed their entire credit file. So now if they try to apply for a mortgage, they don't have an Experian file, which most lenders are not going to approve you if that's the case. So there's
well,
an
that's a
example
whole
of,
other issue though. I mean, I mean, they can't really do that, but they did do that, and they
I
can't
mean,
really do.
if they can do it or they can't do it. He couldn't find a lawyer to take his case. Nobody wanted that case.
No, but what I'm
Um,
saying, I mean, so the problem is real, right? Like, so you're saying
It is a
Experian
problem. I agree
basically.
with you. It's a problem. But again, I would argue in that situation, much more of the blame lies with the customer. And I know in our industry, we don't like to say the consumer or the customer is wrong. The consumer is often wrong. Okay. That's the truth. Like, you know, and that doesn't mean we can't help them, but let's be honest about where the accountability lies. The point I'm trying to make is, if you swing for too much and you're too outrageous, there are consequences.
Well, I think
And the same can apply in arbitration.
yeah, and that's a good point because I mean, it's the same thing where people. I think we need to stay focused on what our business model is as
Correct.
CROs. Like, if we are in the business of charging our clients either monthly or for deletion, okay, well, if that deletion is achieved through litigation or arbitration, then there you go. But what is your fee? But if we're in the business of being CROs,
Correct.
and
You're in the
and a
business
lot
of
of
helping
times we
people
want to get
improve
that.
their credit. Yeah.
We want to. That's right. And a lot of times I hear this, they're like, oh, I want to refer to these attorneys, but they won't really pay me, maybe, but $200 or something for the lead. I'm like, Well, I mean, you're not an attorney, and your business is to get credit clean.
Yeah.
And if you get the credit clean, how many more clients can you actually get? Wouldn't that be amazing, right? So it's the same concept here. Let's not get greedy. Now, because you have a mechanism that as a CRO you can do yourself, which enables you to ask for fees, not attorney's fees, but just fees. Don't get ridiculous, right? Because it's the exact same thing. It's like, what are you in the business of doing, right? And to Shiva's point, it can backfire. And so we need to make sure we stay true to our purpose, which is look,
Yeah.
there's genuine issues. We are truly here because we care about the debtor.
Mhm.
And we have a skill set now, which is arbitration, which is another
Correct.
tool in the toolbox, And if we look at it like that, I mean, yeah, we'd like to get some money off of it, of course. But I mean,
Yeah.
if you can't run a profitable credit repair business, don't think that you're now going to be making all your money on arbitration because it's
No, no, no. I definitely anyone who's thinking of this like, hey, it's just going to be this windfall of whatever. And I know there's groups out there where they're saying that. To each their own, I suppose. I don't like to judge what someone else does, but I will say to those who are on defense and trying to figure it out, I wouldn't dive into it that way. I would ask yourself, if I want to be a CRO that wants to succeed, deliver massive results, have a positive impact, and grow my business, is this a tactic I can use? And for that, the answer is yes. And if that's what you're looking to do, then I'd say it's definitely something worth pursuing.
absolutely. It is amazing. It's an amazing strategy. And I'm so super excited that we're able to get the information out. Let's talk a little bit about the course that you've kind of put together. I mean, because a lot of people were asking for it, and you've got the experience doing it hundreds of times. You're an attorney. So if somebody's watching this and
Mhm.
they either themselves, if they're just a debtor right now themselves, and they're like, I mean, we had somebody sign up. She found my TikTok video the other day, Shiva, and
Mhm. That's
she's
right.
like, "Oh my gosh!" She's like, literally, I was looking at hashtag arbitration to find a course like this, and she found us. And she had just recently filed like a week ago arbitration, and she's like, I need to get your goods because like I need to know what's coming, right? Like, so
Mhm.
whether you're a debtor, consumer, like, and you're doing it on your own, or whether you're a consumer advocate, whether a credit repair company or whatever, what can they expect to get out of the course
Sure.
that you packaged up?
Sure. So we focus on three main areas. Two to start, and we're going to expand beyond that. But primarily, we're focusing on credit card charge-offs, auto accounts, auto repossessions, and to a lesser extent, certain types of collections, meaning telecom and cell phone collections. Okay, those are the main areas. Now, what you can expect is a background of arbitration. When should you file it? How to file it? And then not only that, but it's not just the arbitration, the exact sequence of disputes that you need to set up the arbitration, meaning send this letter to the company, send this letter uh, to the what's it called, to the to the creditor and so forth. What are you looking for? What are you writing? Okay, now you're in arbitration, you're corresponding. What are some of the things you should focus on or bring up in there? Email scripts. I recommend everyone stay off the phone as much as possible. When it comes to this, do things by email. It's just for your own sanity and more importantly for the scalability of your business. You can't be on the phone too much except if it's to make sales with clients. So how much of it can you do by arbitration and all of that? That's really what it comes down to. Um,
So you mentioned kind of the frame up. Okay, so
yeah,
how do you send the letters that kind of lead up to arbitration? So from there, does that mean again, a credit repair company, if we're trying to strategize, I mean, can you kind of do like a factual, hey, here's what's wrong, dispute, wait for things to happen,
yeah,
and then kind of frame it up? I mean, so you should probably have, is it fair to say that like if you're going to be doing arbitration, you should have that in mind from the very beginning because you don't want to be sending out like not mine, never late garbage. And
no,
then do
no. You have a very specific framework,
yeah.
and it's very factual. It's very it's very specific to the client, and um, that's what it is. It's funny, Robert. What did you say? Get off the phone. Yeah, get
Mr.
off the phone.
President himself, he doesn't like the telephone. Yes, do that.
Yeah, it's very factual. So I'll say this in advance. You know, plenty of companies start out where you're saying not mine or doesn't belong to me and those things. There's no shame in starting out there because that's all people know and that's what's been put out there. We rise to the level of what's available sometimes. But what I do want to say is once now that these tactics are available, you can do better. So it's about setting it up properly and then going forward. That's what it really is.
Well, and so kind of what I meant with that though is like if you were going to go arbitration style or even litigation style, well, everything that you've done up to that point is discoverable, right?
Mm-hmm.
And so I mean, like if you've got if you sent out disputes that are less than good, like I mean,
Yeah,
if you're saying like bad,
it's very much, yeah.
like I mean, if you're out there sending like sweeping and bogus police
Oh,
reports and
yeah.
affidavits, don't think that like you can then go to arbitration or litigation and
No,
like
you're closed. All those doors are closed.
you're toast. But
Um,
you can actually, I mean, they can actually like I mean, you could lose in that case because they could
you
be
can
like,
lose, and you at that point you have done something that is frivolous and for the purpose of harassment. Okay,
right.
you are
So
putting yourself in very hot water, and by you, really, you're putting your client in hot water. But your client is going to turn around, and of course, they're going to blame you, and then you end up on the news, just like the woman I saw in Houston recently with all the identity theft cases, and she's in the jumpsuit, not orange. I think it was a more purple one, but nonetheless, she's in the jumpsuit, stuck over there.
Shiva,
Point is,
I'm gonna say, remember the Wolf of Wall Street? That the wife, he said, there's no such thing as bad publicity. I haven't heard you talk about Jesus or Gandhi, but you are talking about the lady in the jumpsuit, and so somehow at least she's got people talking about her, right? So I mean, I guess for our audience,
she does. Unfortunately, I mean, probably not what she was going for. I mean, the funny thing is, I was reading the YouTube comments, and folks, what I sensed was this because I read the YouTube comments on that video, and I don't like to do this often, but I did in this case. And people said, "What's the big deal? She was helping people. The banks screw us." What I saw was a lot of sentiment that people have that consumers and people need help and want help. And so I said, people aren't so much embracing what she did; it's just saying, "I want somebody to help me. I wish there was something we could do." And it really comes from that place, that spirit. And so the truth is, there's a lot we can do to help,
yeah,
legitimately.
yeah.
And
Well,
so,
you had me up.
I think, and today, in this day and age, when there's so many more resources around credit repair, I think every company has an obligation to do a better job with it. Yeah.
Absolutely, Shiva. So, man, I mean, I tell you, we should do more of these, man. We should probably do an arbitration show here in our group, actually. My goodness gracious, man. You guys comment below if you think Shiva is amazing. We should do us like a little show together here. But, and Shiva he's an open door, man. Feel free to send him a Facebook message. If you
Drop me a message, please.
send me a message. We had a wonderful lady. Jennifer was messaging us this morning, asking some questions about she actually was asking really good questions, like high level stuff. I'm like, dude, I don't even know. Let me get you with Shiva. So, man, if you guys have questions about how this can benefit you, what's involved, send us a Facebook message, send us a chat. There's more information at arbitrationtrainingcourse.com as well.
Yep.
So we got Robert here. Robert says do a show. But by the
So
way, Robert,
I'll mention this. Speaking of show, people who buy the course, it includes a Zoom twice a month. That's for people who purchased it twice a month, where I get on with the people in the course, who did that, and we go over their specific concerns and challenges and all of that with the arbitrations. So, and everyone who's buying the course through Steven's group, those Zooms are free through December. It's included in the price of the course. Not to give the sales pitch, but I will. Through December, there's no charge for those Zooms that start in August through December. So you get hands-on, and at that point, we'll figure out what that's going to look like. There's definitely going to be a community around it, and it's going to be something that expands.
Well, Shiva, if you can't give the sales pitch, then who can you expect and rely on to give the sales pitch for you? Right?
Amen.
That's it, right? There was this, I think Zig Ziglar once said that timid salespeople have skinny children because they don't make no money and they can't feed their kids. So there you go. But we joke around, but I mean, in all sincerity, I mean, it's, if we're in, you've got to constantly be skilling up, learning, and arbitration is a powerful, powerful tool. And, you really have me intrigued with the credit card and credit card debt buyer aspect of this whole thing, right? Because those credit cards, I mean, honestly, they are difficult sometimes, right? And if you can use their contract against them,
it can be very effective.
That is,
and I do want to clarify one thing. The credit card debt buyer aspect is something that's still being figured out because there's many aspects to it. It is something that we work on, but I would say right now the repos and the original creditor stuff is a lot more defined. The credit card the debt buyer, the portfolio recoveries, the Midlands, and where they fit into this, that aspect of it is still very much something that is being, that is in flux and is being figured out. But it will be, and arbitration will be a key part of it.
And so, just to clarify, when you say
Yeah.
influx and being figured out, you mean like in the court system? Because
In the court system, and even from a credit repair standpoint, okay? Because I can tell you very clearly, hey, if you have a credit card charge off, here's what you can do with it. With debt buyers, okay, they are bound by it, but in terms of forcing compliance, that aspect of it is still being figured out with the courts and otherwise, yeah. So, if they bought the account, are there things we can do to get it removed using arbitration? Yeah, sure, definitely. But it's not quite in the same realm of being defined yet or being decided that maybe credit cards are, just because the debt buyers have always operated in a weird realm. These guys can't even really prove they own the debts. I mean, at some level, I know they paid for the debt, but you ever notice you file an answer in arbitration in a debt buyer case? As a lawyer, I can tell you, you file an answer and really ask for proof they own it, you'll get that case kicked. They're not going to go forward beyond that. That's always been the truth. Okay. And you ask for arbitration there. If there's an arb clause, you'll get a kick too. Same thing. But in terms of forcing these guys or pulling them into arbitration around deletions, that aspect of it is in flux because there is litigation around that topic right now. But it will be decided soon, and when it is, then I think there's things the group can make use of.
absolutely. Well, so as we take this one in for a landing, again, feel free to message Shiva, myself, go to arbitrationtrainingcourse.com. But if you are at all, I mean, with the pandemic show, my goodness, I mean, things were really rocky for a while with the credit bureaus not doing things right. I mean, so
Yeah.
if you are serious about your game, the nice thing about arbitration, well, here's a whole other thing, right? Is a lot of times CROs get a little twisted up because of that provision in the FCRA, which enables furnishers to disregard CRO disputes. I mean, and we've talked about that in my course and in my videos, where if you've got a legitimate power of attorney, like 99% of the time that clause doesn't even matter. But if you're not using a power of attorney, this arbitration is a way to circumvent all of that and to get you right in front of the furnisher. And I mean, I really think that's what we need to take away.
That is the number one thing, man. The whole credit bureaus and spamming them with letters and going back and they won't do this. Can we sue them? Believe me, FCRA is incredibly powerful. Love FCRA litigation. Okay. But from a credit repair standpoint, I have said this for the last couple of years. The bulk of our results come from the furnishers. Okay. I do notice, there is stuff that like Equifax. I do notice when my law office, which has sued Equifax, sends POAs on certain charge-offs and companies to Equifax, we seem to get a bunch deleted off the batch. That's true, but that's not always the case. And often, even with us, we have to go through the ARB to get it done. And that's what I think folks should focus on. Because the reality is the big three, the only thing that really governs them is FCRA. And if you can do FCRA litigation and all of that. The furnishers, I mean, there's a whole nother game because you can twist their tail with when you've got a good argument, a good fact pattern with arbitration. And it's not something they want to get into if they can avoid it. Yeah.
Well, there you guys go. So the takeaway is if you want to twist their tail, then you want to get into arbitration.
Yeah.
So Shiva, man, appreciate you for putting this course together and for doing this show and sharing this with our little circle here. And then for those of you guys, again, watching, feel free to message below, question us, chat us, whatever you need. And we will see you guys all on the next show, man. You guys all have a great day. Take care.
Likewise.